topics: a general overview of the CARES Act, contractual issues, including real estate leases, how these rules may impact oil and gas leases, and emergent bankruptcy concerns. I'm Scott Schneider, and I'm your moderator today. I'm an attorney here at Hinkle, and I practice in government relations. Today, it seems more like emergency management planning for several of my clients, but I do think the information today will be very helpful in trying to figure out how to, in many respects, survive and reemerge with a meaningful business model. We are going to have a few panels to present our information, and just know tomorrow we will take a deeper dive into employee benefits. And if you know of anyone in the HR field, please forward them the link to tomorrow's webinar. If we do have limited space and it's nearly full, but we can accommodate a few more. To introduce the first panel, I'd like to introduce Scott Pohl. Scott received his undergrad degree from the University of Kansas and his JD from Washburn University School of Law. Following law school, Scott was a judicial clerk for the Kansas Court of Appeals and law clerk for the Honorable John Pearson, U.S. bankruptcy judge for the District of Kansas. In addition, Laura Fent, she is a business attorney practicing primarily in the areas of business and corporate law, healthcare, franchising, securities, mergers and acquisitions, and real estate. Laura graduated in 1998 with a JD and an MBA from the University of Kansas. And finally, Kystle Dalke is an associate attorney practicing primarily in the areas of business and corporate law, healthcare, intellectual property, real estate, and appellate practice. She's graduated Washburn University School of Law, magna cum laude, 2008, as a BS and a BA from Washburn also, both magna and summa cum laude. So I will hand this over to Scott and the panel. Thank you, guys.
Thank you, Scott. Appreciate everybody joining us today. I'm sure many of you have received information over the past 2 weeks regarding the CARES Act and the various attributes of it. We're going to try and cover some of those today in a little more detail. And really what I'm going to try to do to start off with is kind of point out to maybe a few things that aren't being discussed with regard to the CARES Act, at least not so far as the national press I don't see as pointing out these issues, and are items I think are important for businesses to understand, and a resource that is available to you through the CARES Act and through the government. So, and then when I get done, I'm going to turn it over to Laura Fent, who will talk a little bit more about the Paycheck Protection Program. And then after Laura gets done, she'll turn it over to Kystle, and Kystle will talk to you about the EIDL grants and loans and give you more details as to those. So I'm going to kind of shy away from those two topics and focus a little bit more about the CARES Act. By the way, if you do have questions, go ahead and send them in. What we'll try to do is take questions at the end of this session. So after Kystle gets done with her presentation, your questions will pop up, and we'll try to go through those as many as we can as time permits and get your questions answered. Understanding that, as you probably have experienced and as we experience, this is an ever-changing field. I even heard this morning the discussion about, more discussion about the modification of the CARES Act to increase the size of it. So, and in the amount of available funds. So we'll try and keep monitoring those things. And obviously you can reach out to any of us at any time, but if you have questions regarding the CARES Act and how it may apply to you. We will shy away from the employment type issues and the retirement benefit issues today, because that's not our forte. We're in the business transactions, commercial real estate. I do oil and gas. Those types of issues are what we're going to hit primarily today, as well as a little bit of the litigation side. So before turning to the Paycheck Protection Program or the EIDL program, which are again fairly hot topics in the news, and which everybody seems to be wanting to take advantage of. I'm going to point out a little piece of the legislation that tends to be overlooked, and is something that I think can provide a great benefit to you. And that is, by the way, in front of me is the CARES Act. It's 800 and some odd pages. I have not read it all. I will readily admit that. I'm guessing most people have not read it all. We focused on specific portions of it. So what I'm going to turn to is a section that's not discussed much, and that's section 1112, which talks about subsidies for loan payments. And just to let you know that the Paycheck Protection Program and the EIDL are obviously new attributes to the SBA concept, but they're not the only types of loans that the SBA makes, and they're not the only types of loans that are addressed in the new CARES Act. While the CARES Act doesn't expand on the existing loan situations other than these two, the EIDL and the Paycheck Protection Program, it does address the existing loans and gives you some relief from those. So in a section 11.11.12 of the CARES Act, there's a kind of a unique provision in there that indicates that the SBA will help you out with regard to what's called a covered loan. Now, interestingly enough, covered loan does not include the Paycheck Protection Program or the EIDL, but it does include the significant number of other types of loans that the SBA has available to you. And I'll briefly talk about those, but more importantly, those are probably available through your SBA office or your lender to go talk with to get a better understanding of all of those types of loans. But a covered loan is essentially most of the SBA loans, or all the SBA loans made, other than the other two that we're going to generally talk about here today. And what's a benefit to this program, and again, that people probably should look to take advantage of, is that it requires the SBA, or tells the SBA, that it's going to pay your principal, your interest, and your associated fees on those loans for a period of 6 months. So if you are currently under an SBA loan program, you should be reaching out to the lender SBA to get that relief of 6 months of payment of principal, interest, and fees during the 6-month period. The bright side about this program also is that you didn't have to have an SBA loan in place in order to take advantage of this. In fact, you have a 6-month window from the date the CARES Act went into effect to go out and apply for a different type of SBA loan and get the advantage of having 6 months of your principal, interest, and fees paid by the SBA. And there's a provision in the new CARES Act that says, to the extent any amount is paid by the SBA, it's going to be applied to cover that loan and considered that portion of the loan as having been paid. So essentially, again, we talked a little bit about free money in the world, and this is a situation where if you're in need of a loan and maybe the programs we talk about here today don't cover those needs, you can always go to the SBA and seek out a different type of loan. And as long as you do it within 6 months, you should be entitled to get the 6 months of principal, interest, and fees paid on your behalf. Now, again, talking about other types of loans that are available through the SBA, there is a number of those loans. And truthfully, in this program, we probably don't have time to detail out all of those types of loans. There are 7A loans, which are up to $5 million, where the SBA guarantees a portion of that loan, depending on the amount of the guarantee. They have interest rates that are somewhat flexible, and you can negotiate those. There's a guarantee fee that you pay to the government. And these proceeds are used for expansion, renovation, new construction, purchases of lands and buildings, fixtures, leasehold improvements, working capital, refinancing of debt, seasonal line of credit, inventory, those type of things. So it's called a 7A loan, and that's something if you are going to an SBA or going to your lender, you need to ask them about the 7A loans. There's 7A loans, there's 7A small loans, which are up to $350,000, and they have some of the same parameters as the 7A loans. There's SBA Express loans, there are SBA Veterans Advantage loans, there's capital loans, capital lines loans, there's international trade loans, there's export working capital loans that are available. A big one is what you hear talked about a lot with the SBA is 504 loans are out there. And 504 loans, again, have a $5 million to $5.5 million range, depending upon the project. They're long-term fixed asset loans that you work with the CDC, which is a certified development company to assist you with those processes. But those loans are also out there. And then there's also 7A microloans. So I don't want to detail all those out. Some of those I found on the SBA website aren't dressed very well. You have to dig a little bit to find information on those types of loans. But my reason I point those out is my concern is that if this process continues for a longer period of time, the pandemic, and the shutting continues for a period of time, your businesses may be affected more than just the payroll issues that you're trying to cover with the programs and the loans that are out there. You may need other types of loans to get you through that process, and through the SBA, you can do that and again get your principal, interest, and fees paid for a 6-month period. So obviously, I think the lenders and the SBA are probably very well inundated right now with a lot of applications coming in. I don't know whether these loans will be available through all lenders. As you probably are aware, the number of lenders that can make certain types of loans, the Paycheck Protection Program loans, is expanded. I think with these types of loans, you're probably going to have to go back to your either your preferred SBA lenders or those that have been authorized under the SBA to make these types of loans. But I would encourage you to check that out if you feel like there's a chance that your business is going to need more assistance in the future, and hopefully this will provide you some relief in that process. So with that, I'm going to turn everything over now to Laura Fent.
Good morning, everybody. Thanks for joining us. There's a disclaimer, which you guys can read. My name is Laura Fent. I'm an attorney in Hinkle's Business Transactions Department, and I'm here to speak to you today about Paycheck Protection Program loans, or PPP loans, and also about the process. As you all know, the CARES Act was signed into law on March 27th, 2020. The Payment Protection Program has gotten a lot of buzz in the news, and it was promulgated pursuant to that act. Lenders started taking applications on April the 3rd, 2020, and these loans will continue, as far as we know right now, through June 30th, 2020. Everything is moving very fast. The SBA, the night before lenders started taking applications, the SBA issued interim final rules on the 2nd. They're looking to receive comments over the next 30 days, but we're supposed to follow those to the extent that we can until things change. The SBA application forms for these loans, it's a little bit of hyperbole, but it seems to be changing almost on a daily basis. And so all that said, there is a lot we don't know just because things are moving so fast. We even hear that certain small businesses, if they don't have a current borrowing relationship with their bank, are being turned away for these loans. So we will do our best to let you know what we know right now, but keep in mind that we've all been living with this act for maybe a little less than 2 weeks. So why should your business be interested in this kind of loan? Well, the wonderful thing about these loans is that the SBA and the government wants you to be able to pay your employees, keep your employees on the payroll, and give you dollars for kind of mission critical kind of expenses. So we're talking about payroll, interest on any mortgage obligations, rent, utilities, and interest on other debt obligations. Now, with respect to the non-payroll type expenses, this is not kind of a growth opportunity. These need to be with respect to obligations that were in place by February 15th, more or less. The other thing to note, and this came out in the interim rule, even though there was an indication in the application that this might be the case, is that only 75% of the loan proceeds or 75% of the loan proceeds must be used for payroll. And so non-payroll items must be kind of thrown into that other 25% bucket. So why, again, why should you apply? Well, really, because this is the best loan you will ever get. It's got full forgiveness, as long as the amounts that you use are expended, or that you apply for, expended upon those items that I just discussed. The loan, other than, in addition to the forgiveness element, the loan terms are very favorable. The forgiveness amount is excluded from gross income for tax purposes. There are no personal guarantees or collateral. There's elimination of most of your typical kind of origination type fees and processing fees. There's no recourse against owners as long as they use the loan proceeds for an authorized purpose. Maximum 4% interest rate. Currently it's set at 1%. Out of the gate, it was supposed to be 0.5% or 50 basis points. Lenders did not like that, and so they pushed back, and so SBA bumped it up to make it attractive to them. Also, in a similar vein, there was supposed to be a 10-year payment period. Lenders didn't like that so well, so right now it's 2 years. That might change again depending upon what gets finalized in the interim rule, but that's where we're at. Wonderful deferral of payment of principal, interest, and fees for up to 6 months, not to exceed a year. Keep in mind that you will be, or interest will be accruing during this time period, but there is deferral, no prepayment penalties. So all in all, a very attractive loan and a streamlined process that the lenders do not have an obligation to vet this as thoroughly as they typically would. Really they're supposed to be relying upon the certifications that you make. So, who are these loans intended to help? They're intended to help small businesses and small business concerns as historically defined by the Small Business Act. But other than that, it really is any other business concern with fewer than 500 employees. And that includes nonprofits, veterans organizations, tribal business concerns. And I might mention, if you have more than 500 employees, you might be able to still meet this criteria. It's on an industry by industry basis based upon what the SBA feels is the size standard for that type of business. All these types of business must have been in operation as of February 15th, 2020, and must have employees and independent contractors. That said, there is also relief for sole proprietorships, independent contractors, and eligible self-employed individuals. And then there's also, I'm going to turn this over to Scott Schneider, since he's closer to the accommodation and food services industry, but there are also special rules for that industry.
Yeah, thank you, Laura. We do work with the Kansas Restaurant and Hospitality Association, so we've been on the front lines of this one a little bit. So within the accommodations industry, generally they use the NAICS code of 72, so it's the accommodations and food services. If your business is in that code, you're going to qualify. Additionally, there's been some questions about the 500 limit. Does that apply to a series of stores, whether it's the franchised model or also a series of hotels, that you have multiple hotels and you have more than 500? They said the qualification is going to be by location. So no more than 500 at a location. So you can have a series of these business enterprises that you can imagine have multiple locations that would still qualify. So they have tried to make this broad for that business sector in the accommodations and food services. I'll hand it back over to Laura.
Thanks, Scott. Appreciate it. And then just a couple more things before we move off this slide. Again, just because things are changing so rapidly, as of yesterday, it turns out that foreign-owned businesses can still or can apply for these loans. Previously, the SBA application was set up that foreign-owned businesses could not apply. So it'll be interesting to see how quickly foreign-owned businesses with U.S. employees can apply. The other thing I wanted to point out is that we kind of dived a little bit into this definition of eligible self-employed individuals. That is a defined term under the CARES Act that is kind of harkens back to the Families First Act. So that is actually a fairly narrow definition. An example would be if you're a self-employed individual, you come down with coronavirus and need to self-quarantine for 14 days. It's intended to help individuals in that kind of situation. I believe that there are 6 other factors, but I won't go into those here. So, how much of this free money, if you will, can I get? Unfortunately, it's not an astronomical sum. It's the lesser of $10 million, which isn't bad, of course, but it's pretty much capped at 2.5 times your monthly payroll cost. So even though we discuss all those things that you can use the dollars for, the calculation is limited to 2.5 times payroll cost. However, if you have taken out a disaster loan, which Kystle Dalke will speak to a little bit later, one type of those, and you choose to refinance it under the terms of the PPP program to get the more favorable loan terms, that will bump up your 2.5 times payroll cost upper limit. For purposes of loan forgiveness and also figuring out how much you can borrow, employee is a key definition. And it's fairly broadly defined as those who are employed on a full-time, part-time, or other basis. I would note here that, for example, independent contractors are not included in this definition. It's really meant to be employees, and I think the theory is that independent contractors can apply for these things on their own, so we're not going to include them in how we calculate employees. So now I want to take a little bit of a deeper dive into payroll costs because, of course, this is kind of critical for figuring out how much you can borrow. So pardon me for diving into the details here, but it's the average total monthly payments by the applicant for payroll costs incurred during the 1-year period before the date on which the loan is made. The SBA application kind of says, well, you know, most people it's going to be your average in 2019. It may say that, but in the act itself, it's a 12-month trailing period look back. And I believe in the interim final rule, it also couches it that way. Now, if you're a seasonal employer, the SBA makes that determination, but then at your election as the seasonal employer, you can pick between the period beginning February 15, 2019 for 12 weeks, or the period beginning March 1, 2019 to ending June 30th, 2019. I don't know the reason behind those timeframes. I haven't seen that yet, but I'm sure we'll all get educated on that in the weeks to come. So that kind of tells you how we're calculating payroll costs. And now let's focus on a little bit more detail as to what payroll costs we're really talking about here. So again, with respect to employees, we're talking about salaries, wages, commissions, or similar income, payment of cash tips or equivalents, payments for PTO type things, allowance for dismissal, so kind of severance payment type payments, healthcare, retirement benefits, and state taxes are included on compensation of employees. In Kansas, that's pretty much just unemployment costs. One of the things that we're wrestling here internally and wrestling with for our clients is whether partner distributions would be included in an LLC since partners are not employees. it seems like an unlikely result to have, say, in a corporate environment, an S corp or C corp, to have stockholder employees who could avail themselves and be included in payroll costs, but not LLCs. We kind of wrestled through this, and about the same time we had come to our kind of conclusion that it could go either way. What we have seen in the national press and in our trade periodicals is that they also agree nobody really knows the answer to those questions. So we're hoping that there will be additional guidance in the next several weeks, since you need to know one way or the other to apply for these loans, and you can only apply for it one time. So it's kind of a critical issue. Not included is the compensation of any individual employee in excess of $100,000. So in effect, right, simple math, that means that anybody who usually gets over $100,000 in a year is limited to $8,333.33 per month. Also, federal taxes are excluded from your calculation, which makes sense. The government doesn't want to pay you to pay them. It is only with respect to employees in the United States. In other words, this is trying to help U.S. employees stay employed. So we don't want to use any of these funds for employees outside the U.S. And then, and this is kind of a common theme in the CARES Act, that if it's a credit that you've been paid for under the Families First Act, you can't get credit for it here. So no double dipping. As I mentioned previously, the application seems to be changing almost on a daily basis. That's, again, probably hyperbole, but there have been a lot of changes. Currently, there are 16 certifications that borrowers must make. I'm not going to go through them all here, but the important ones seem to be, you do have to certify, and you make a good faith certification that due to the uncertainty of the current economic condition, that this loan is necessary to your ongoing operations. Also, you've got to acknowledge and agree that you're going to use the funds for the intended purpose, which is maintaining payroll, mortgage payments, lease payments, utility payments, and that not more than 25% of that amount can be used for non-payroll costs. And then finally, you must certify that between now and the end of this year that you're not going to receive other amounts pursuant to the PPP program. Again, the no double dipping rule. So this is probably not exactly on point, but assuming that you've done all this, you will be eligible for forgiveness. And so in the next kind of 8 weeks, there are some things that you're going to need to be thinking about, that you're going to want to make sure that you keep on top of to make sure that you're eligible for full forgiveness. So during the next 18-week periods, you want to make sure that you only use those funds, and we would recommend having a segregated account to pay payroll costs, to pay the interest on your covered mortgage obligation, your covered rent obligation, covered utility payments. And then you want to keep in mind that if you lose employees, you will take a pro rata hit on the amount that will be forgiven. So the way this is calculated is that you would take the average number of FTEs per month during that 8-week period, and then you would divide them by, depending upon how you calculated it at the beginning, we're presuming, by the average number of FTEs per month employed during the period between February 15, 2019 and June 30th, 2019. The average number of FTEs per month employed during the period beginning on June 1, 2020 and ending on February 29, 2020. Or if you are a seasonal employer, as determined by the FBA, it would be divided by your average number of FTEs per, starting on February 15, 2019 and ending on June 30th, 2019. And I believe that in terms of how you calculate your average, you're looking at each payroll period. So not necessarily even a monthly average, but maybe within that month, your payroll period average. And then in addition to kind of looking at your total employment numbers, you would also take a hit in the amount that could be forgiven if you reduce wages. So they will be looking at the, during that 8-week forgiveness period, if there is a reduction in excess of 25% of the total salary or wages of the employee during that most recent full quarter during which the employee was employed before the 8-week forgiveness period. Okay, if, as soon as all this stuff started happening, between February 15, 2020 and April 26, when the law was signed into effect, if you reduce salaries, if you laid off people, all is not lost. You're fine. You have 8 weeks during that period to get your FTEs up and to increase your wages. If you do that before the end of the 8-week loan period, forgiveness period, after that loan has been originated, you will be eligible for full forgiveness. So you've made it through the 8-week period. You've done everything absolutely correct. You're eligible for full forgiveness. What happens next? Now, at this point, you'll need to go back to your lender and you will need to request forgiveness. And it's almost like a little bit of a separate application process. As part of that, it'll be very similar to what you did on the front end. You will need to provide them documentation with respect to your employees that include payroll tax filings, state income payroll and unemployment insurance filings with respect to the non-payroll type items, provide canceled checks, payment receipts, transcripts of accounts, and other documents relative to your payroll, your non-payroll items. So segregated account, keep track of all these things as you go so that it'll be easier for you to apply for that loan when you get there, or that loan forgiveness when you get there. You also have a certification on the back end that you use, that documentation is true and correct and used for a good purpose. And the SBA can ask you for whatever else it wants to as well. And then you're done. That's it. The lender must give you a decision within 60 days and you're through the process. So we know this isn't riveting stuff, but we're doing the best we can to go through kind of another loan that is going to be important, we think, for small businesses. I'm going to turn this over to Kystle Dalke so she can discuss EIDLs.
Thank you, Laura. Yes, I am tasked to discuss economic injury disaster loans. As Scott mentioned at the beginning of this presentation, the economic injury disaster loan program was in existence prior to the CARES Act. Really, the CARES Act just expanded the definition of eligible entities. It increased the number of businesses and organizations that can take advantage of the EIDL program. It also waives certain restrictions, reduced certain barriers that would have precluded businesses and organizations from being able to take out loans pursuant to the EIDL program. So it's a good resource that if you haven't looked at this, you might want to take a look at, because it provides some different types of relief than the PPP loan in your existing 7A business loans. So the purpose of the EIDL program, it is a working capital loan that eligible entities can use to pay kind of the cost of doing business as a result of lost revenues and economic crisis that is going on due to COVID-19. Eligible expenses include fixed debts, which is your rent or mortgage payments, payroll, accounts payable, or other costs that could have been paid had there not been the economic injury to your business as a result of COVID-19. Now, one caveat to the payroll costs is the CARES Act does not want you to be able to double dip, meaning that if you included payroll costs for the PPL application, you calculated those payroll costs to obtain a loan under that program. You should not also use the EIDL loan funds to be able to pay for those same payroll costs. So these are separate payroll costs. Maybe if you had employees who were over that $100,000 salary threshold, but you can't double dip under both programs. On the other hand, EIDL loan funds are not to be used for expansion of your business, acquisition of fixed assets. This isn't a time to try to grow your business. You shouldn't use them for dividends or disbursements to stockholders or owners of the business unless it's to pay them for services actually rendered. You should not use EIDL funds to repay stockholder or principal loans, refinance other debt, or like Laura mentioned earlier, the federal government doesn't want you to use their money to repay on federal loans or federal debt. There is an exception for IRS obligations, and similar to the no expansion rule, you should use EIDL funds for relocation of business and costs associated to those. The covered period for the EIDL program begins on January 31, 2020 and ends on December 31, 2020. So what that means is you have a little bit longer time to apply than under the program protection plan program, but the paycheck protection plan program, but you don't want to wait till the end of the year to also take advantage of this. The CARES Act allocated $10 billion towards the EIDL program, so it's better to get in line sooner rather than later if it's something you think your business is interested in. And the expansion of the eligible entities is only through the covered period, so if you wait until next year, 2021, you might no longer be eligible to apply for an EIDL loan. Eligible entities include those that are small businesses with less than or equal to 500 employees, as well as co-ops and employee stock ownership plans with greater than or equal to, less than or equal to 500 employees. It also includes sole proprietorships with or without employees, as well as independent contractors, small agricultural co-ops, private nonprofit organizations, and then businesses that might be over that 500 employee threshold, but still meet the SBA's definition of a small business under its size standards. Moving forward, eligible nonprofits include those entities that are tax exempt under sections 501c, 501d, and 501e of the tax code. They also include nonprofits that are organized and registered as a nonprofit in its applicable state under existing state law, and you need to be able to prove it. So you have to provide sufficient evidence that you are a nonprofit organized under your state law. Also includes faith-based organizations. Moving back, so the terms on EIDLs, they're capped at $2 million. So each loan you could get up to $2 million. They have low interest rates, a little bit higher than the PPP loan program. Nonprofits enjoy 2.75% interest rate, and the small businesses are a little bit higher at 3.75%. There are longer repayment terms for EIDL loans. The maximum is up to 30 years, but the length of the repayment term is determined on a case-by-case basis. really what the SBA looks at is your business or organization's ability to repay the loan. There is deferred payments for 12 months, but interest does accrue during this time. And eligibility is based again on size and type of your business, as well as your financial resources, and you're showing that you're able to repay the loan. Now, the approval process is fairly straightforward. You have to show an acceptable credit history and your ability to repay an SBA loan. You also have to show that your entity was in operation as of January 31, 2020. This is a little bit of a relaxed requirement from the typical EIDL program that required your business or organization to be in operation 1 year prior to the disaster or economic injury. So the CARES Act relaxed that requirement, and all you have to do is show that you were in operation as of January 31 of this year to take advantage of the EIDL loans under the covered period. Additionally, the SBA requires the following information for the past 12 months. So really you're looking at that February 2019 through January 30 of 2020 time period. They want to know gross revenues, cost of goods sold or cost of services, lost rents, and this is for your rental property owners. They also want to know cost of operating expenses, but this is limited to nonprofit organizations. They also want to know if you're expecting any types of reimbursements, either through grants or if you have business interruption insurance or other insurance policies that might cover any of your lost revenue stream, your number of employees, the federal loan history, if you have any. And another interesting aspect, which is also, is my understanding on the PPP loan applications, they do look at the moral character of the entity and its owners. So for example, they ask questions like, is your business engaged in any illegal activity? How much of the funds or how much of the revenue is derived from gambling or maybe activities of sexual nature? They also look at owners, if they have any criminal history, as well as your majority owners, if there's any outstanding child support that needs to be taken care of within the last 60 days. So there is some kind of disclosure, self-certification requirements that the applicants need to disclose to the SBA. Now that sounds like a lot of hoops to jump through to get this type of loan, but the CARES Act did waive certain restrictions or reduce those restrictions. For example, you don't have to have a personal guarantee for loans that are less than or equal to $200,000. There is no requirement to show an ability to obtain credit from other sources. Also, you don't have to show a tax return. I think there was some maybe discrepancy between earlier, kind of before the March 27 final rule came down, but you do not have to show a tax return, and this makes sense because if your business was not in operation until January of this year, you wouldn't have a tax return. Also, there's no separate declaration that the SBA must give for your specific state or county that there's a disaster in that specific state or county or economic injury. So there's no requirement for that. Also, the CARES Act implemented the EIDL emergency grant component to this program, which is pretty exciting for people who want to apply for this and need immediate funds. Applicants can request an advance of up to $10,000 on their application. And under the CARES Act, the SBA administration is required to disperse those funds for the advance up within 3 days from receipt of the application. Also, there's no obligation to repay the advance, except that, and this includes even if the the applicant is later denied an EIDL loan. So like Laura said, it's $3 that you would want to take advantage of if you're interested in an EIDL loan. The only catch to that is if you do receive a PPP loan and funds are later forgiven, then any advance you receive through the EIDL program will be reduced from that amount that is forgiven on a PPL. So again, the CARES Act doesn't want you to really be able to double dip and get to use federal dollars more than once. Similar to what's covered under the EIDL loan process, advances can also be used to cover paid sick leave for employees who are unable to work as a direct result of COVID-19. Payroll separate from the payroll costs covered by the PPL. Again, you can't double dip there. Increased costs due to supply shortages. It's harder to get materials or supplies, so this could be used for that purpose. Rent or mortgage payments or other debt obligations that could have been covered had you not suffered an economic injury or reduced revenues as a result of COVID-19. The application process is fairly straightforward in that you can apply directly on the SBA website with the SBA administration. As Laura mentioned, we've had several clients comment about how it's been difficult to work through the Paycheck Protection Plan program with lenders. They haven't had an existing, whether they haven't had an existing relationship with that lender or the lenders are requiring you to use certain software or have a business account. With the EIDL program, it should be a little bit easier where you apply directly with the SBA. There's no lender involved. Also, the funds come from the U.S. Treasury, and you can go online and provide all of the information directly to the SBA, or you can always download the application and mail it in, whatever you prefer. There's no application fee. Also, there's no requirement to accept the loan upon approval. So if you think that you might be interested in this, it's always better to apply and turn it down later to get ahead of the game. And there's kind of a default interpretation because the CARES Act did not address anything on the collateral issue. The standard SBA rules are presumed to apply, meaning that if you want to take out an EIDL loan more than $25,000, then you will have to secure it with collateral. It's my understanding from looking at materials that the not having collateral ready to go in the application process is not necessarily an automatic bar, but it's probably something you'll have to work through with your loan officer. Also, if you have an existing EIDL loan, you can apply for a new one under the covered period. You just can't consolidate those two loans. And then also remember, you can't use funds from the second or new EIDL loan to pay off your existing EIDL loan. And with that, if you guys have questions, it sounds like we have time now to address those and can also ask questions as we go through these, or if anything else comes up, reach out to either one of us about the information you heard today. Any questions online? I did possibly out slides we provided after.
Yeah, we'll be happy to send you what slides we have. You bet.
Absolutely. Well, the slides will be made available. I don't know how those will come out, but we'll try and find a way to get the slides out. Okay. We'll email them out. So if you make the request, we'll email those out. Appreciate everybody's attendance. Obviously, these are were kind of a flyover. We gave you some of the details. We couldn't get into a lot of them. So I'm sure there are questions, or as you go through your application process, you may have questions at that point in time. Feel free to reach out to anybody here that presented today, or any other attorney you work with in the firm to talk about these types of issues. We're more than willing to help you out. This is obviously a moving target for everybody, a moving target for us. Hopefully the information we presented today gives you, obviously there's been a lot of national coverage on the PPP loans, the paycheck protection loans, not so much on the EIDLs or the other benefits that you can get by just having an SBA loan. So hopefully that's broadened your horizons a little bit and given you a little bit of a chance or opportunity to look for if you need cash and need other loans to find those through an SBA program that provides you some benefits. So again, thank you for your attendance, and we're going to actually slide to the next group. And I apologize, we're not totally sophisticated, but you're going to see me sit here still, and Laura and Kystle will walk away. And I have two other presenters coming in for the next portion of the presentation. So thank you very much.
Thank you all.
Laura and Kystle, thank you. I would like to say that we've had quite a few different clients already have some success in these loans. They've been approved, and a lot more in the pipeline. So it's a meaningful path to pursue, even though you have differently positioned companies, and the facts are different on the ground. So those do matter. But now I'd like to introduce Casey Jones and Tom Gilman. Casey joined the Hinkle Law Firm in the fall of 2011. He practices primarily in the areas of energy and oil and gas law, representing private, public, governmental entities, as well as businesses whose portfolios include energy-related endeavors. He has a JD from Washburn Law School, a magna cum laude, and a BA from the University of Kansas. Tom Gilman has more than 30 years in practice and has represented clients on all sides of bankruptcy proceedings, including debtors, creditors, and trustees. He also is from Washburn School of Law in 1983 and has an undergrad in economics from Washburn. Gentlemen, I'll hand this over to you.
Thank you, Scott. The purpose of this segment of the presentation, obviously there's been a lot of national press on, as we just the prior segment, on the types of loans available. But we realize that as you being out there in the world in business, there are a number of other issues that are popping up that you're having to deal with on a daily basis. And so what we've tried to do is think of some of those topics. Obviously, these are topics that we've been fielding from clients who've been calling us. Casey and I on the oil and gas side. I've got commercial lease side, loan side. Those type of questions are floating in, and Tom on some of the litigation side too. We thought that we would try to hopefully hit the topics that some of you are coming across in your business, and give you some ideas of what we're seeing or what we're talking with our clients about. So the first thing I'm going to do is I think I turned it over to Casey to talk a little bit about, because he's got something that relates a little bit to the CARES Act and also some of the oil and gas type of issues. So I'll turn it over to him briefly here.
Yeah, so since you just kind of set through a presentation that touched on loans and stuff like that available for the CARES Act, I thought it would be good to hit one area of the CARES Act that may apply to particularly oil and gas operators, maybe a little bit differently than most other businesses. And that's in some of the things that are covered that you're allowed to pay for with these loan funds that aren't payroll. Obviously, the main thing that's covered by the act is payroll, but there are other things, and two of them. One is covered utilities, and one is interest on a covered mortgage. And the reason these might apply a little bit differently to oil and gas is because in the case of a covered utility, it includes distribution for electricity. If you're an oil and gas operator, you use electricity a lot of times in more than just your office building. Oil and gas leases a lot of times will run off of electricity. And the act itself doesn't go into much detail as far as where the electricity needs to be used or anything like that in order for it to be included in this covered utility description. And so it seems like so long as it's electrical service that was in place before February 15th, 2020, and you use that electricity and you pay for it during the 8-week period that's considered the covered period, that's pretty much the only considerations right now for it to be considered a covered utility. So that might be something that you could look into as far as an oil and gas lease operator is if you have money from these loans left over, that's something that you could apply those funds to. Now, one thing with the covered utilities is there is some language in the act, and I think more so in the application for these loans, that indicates there might be a cap on how much funds you can use for a covered utility. I believe that's 25% of the amount that you use to pay for payroll. And so that cap is actually going to move and be different for every company depending on how much payroll you're actually paying with these loan funds. But that's something to think about. If you have additional funds from these loans, that might be one place you can put it. The other thing is, as I mentioned, interest on a covered mortgage. A mortgage that is covered by this act is any mortgage of real or personal property that was existing before February 15th, 2020. Again, unlike some other businesses who may just have a mortgage on a residence, or real property like a building or something like that, oil and gas operators sometimes have mortgages on their leases. These are typically personal property interests in Kansas, but that's covered by the description of a covered mortgage in the CARES Act. And so, again, if you have interest payments on a mortgage that existed before February 15th, 2020, those are things that you might be able to use the loan funds towards.
Yeah, and get forgiveness of those.
Yes, and forgiveness.
Get forgiveness of that portion of the loan that you use. So we do try to think a little bit outside the box in that regard, even on rent payments that you can get forgiveness of. You may be thinking of your office, but if you're renting space for storage of material, we kind of view that as rent obligations. So if you've got maybe if you're renting a lay down yard or something like that in the oil and gas arena, you might be able to utilize that rent as part of where you're going to apply that 25% to get debt forgiveness of. So I think the law was obviously drafted fairly rapidly in a hurry. There's some, think outside the box when you're trying to think about these types of places where you can utilize those funds. Other than on the payroll side, you've got to, 75% generally needs to be applied to the payroll side, but the other 25% where you can utilize those funds, because some of you may own your building and may not have a mortgage on it, and so you're struggling with where that 25% can go. And if utilities, like Casey mentioned, on your lease or your wellhead, your lay down yard rent, those type of expenses you might be able to put inside your application on the forgiveness side of the equation. So try to think outside the box, and obviously if you have questions on that, you can reach out to Casey on that. Kind of turning over towards a little bit, again, Casey and I practice in the oil and gas arena, I practice in the commercial real estate arena, so we're seeing frankly a lot of the same issues that are floating around, and we've been bouncing a lot of these issues off Tom too, of trying to figure out what to do with some of these things. And the hottest topic that came out, I would say almost out of the chute immediately from my clients literally on the commercial real estate side, was you have tenants immediately. Well, initially you had China as a country declaring a force majeure event had occurred on all of their contracts, and then you have various tenants coming in and saying that they're not going to pay their rent. They believe it's a force majeure event or some other excuse for not paying rent. And we understand that you in the business world, you've got business decisions to make, and you've got to balance the interests. So the best we can do is provide you kind of the law side of the equation. Obviously that may not be where you head with the situation, because you've got a business decision making. You've got to find a way to keep going during these tough economic times. But we wanted to go ahead and hit on the force majeure concept a little bit, as well as some common law defenses to contract enforceability provisions. So starting off with kind of force majeure, what's interesting is everybody throws the word force majeure out there like it has some known meaning in the world. It's thrown out by attorneys even with the concept saying, well, it's a force majeure event, when the reality of the situation is force majeure is really not a defined term. You have to define it yourself in your contract. And so that's why we are telling our clients to go back and look at your leases, go back and look at whatever loan documentation, go back and look at whatever contract you're dealing with, and look to see how the term force majeure is defined in that contract. There are so many different ways in which force majeure is defined. I've probably seen it defined in hundreds of different ways over 30 years of practice, if not thousands of different ways. And everybody thinks it all means the same thing, but it does not. So you need to be mindful. And I tell my clients immediately, go back and look at your lease, your contract and agreement to see how it's defined, because that's what's going to control in your particular situation. Casey and I were having a discussion the other day in the oil and gas arena, and I was actually talking on the real estate side. I'd say it's pretty rare for me to see the pandemic, epidemic, force majeure provision being defined as including both pandemic or epidemic. And Casey, I think, said that he has seen it more often than I have on some of the contracts, at least as he's been looking at.
Yeah, I've seen it a few times. Actually, it was just a month ago, I was going through a lease. It would have been a new lease, and it had those terms defined in the force majeure clause. But I would say more often than not, those terms aren't included, but I do see them occasionally, and those would certainly be things to look for this time.
Right. So keep in mind too, your force majeure clauses, and this may be a going forward type of issue. Force majeure clauses can be drafted again to cover whatever topic you want them to cover, so to speak, and can be covered for issues such as notice and duration of the force majeure event, whether it covers payment. I was looking at a commercial lease the other day on a national tenant, and their form lease simply says, it defines what force majeure is, but it also says that a force majeure event does not protect them against payment obligations. So it may stop your national tenant from having to refurbish the parking lot or repair the parking lot or maintain something, because that may be a performance obligation. But if your force majeure clause specifically excludes out payment obligations, they can't use it to defend against a rent obligation that they owe you, or maybe even a taxes obligation, or a CAM charge, or another type of cost. So I strongly encourage you, when you're talking with your tenants in whatever arena you are currently working in, that you go back and look at those contracts and see how it's defined, and see whether or not there are certain exclusions to it. Again, a payment exclusion, or you have to give notice within 10 days of the event of the force majeure in order to take advantage of it. And then it's only good for so long, maybe 30 days is the maximum period of time. Those would be unique provisions, but I have seen them. And that's why I'm telling everybody to look at those. So.
Yeah, and I would say that as far as Kansas goes, the case law discussing force majeure, in particular related to oil and gas, is very minimal. I think there's one state case out there that really even touches on it, and it doesn't go into much detail. The one kind of thing to take away from that case, though, is in that instance, the court said that a downturn in the market, or in that case in particular, the purchaser going bankrupt, was not covered under the force majeure. I mean, under what they considered a kind of a typical force majeure event, although that's not standard because every contract defines it differently, and so it may be different in another case. But it's something to be aware of, that we do have that one case out there saying, even if your purchaser goes bankrupt and leaves you without anywhere to sell, or leaves you with no revenues coming in, that wouldn't qualify as a force majeure event unless your contract specifically covers that.
Let's assume that your contract doesn't have a great definition of force majeure for you. It doesn't set up the way you want it to be set up, or doesn't have the pandemic, epidemic kind of concept that may be in there that you need at this juncture to deal with the situation. Keep in mind that there are also common law defenses to, and sometimes statutory. There's one that I'll talk about a little bit on the statutory side that can come into play in connection with you addressing the current economic environment and the current situation with your tenants. And some of those common law provisions actually you'll see get shoved into a force majeure provision. For example, act of God. While act of God is essentially a common law defense, you'll see a lot of attorneys belt and suspender these things and put act of God as also being a force majeure event. So the lines get blurred, and just understand that if your force majeure clause isn't broad enough for what you need it to cover, there may be other remedies available to you, or in this case, maybe even to your tenants if you're the owner of the property, to find a way to assert the right not to perform or delay the performance of an obligation. So I want to talk about a little bit of those, walk through some of those common law. And the first one obviously is an act of God. And I think we all understand act of God, or we think we understand act of God, but the reality is I'm not sure we all understand act of God. And to be honest, I'm not sure the courts always have the same concept of act of God. I will tell you that over the weekend, I did a search of a national database for cases that deal with act of God and deal with pandemic or epidemic. And the strangeness of the situation is that I found cases back even to the 1850s where the cholera outbreak occurred, and a gentleman was walking off of a kind of a sawmill site because he was afraid of cholera, and they were suing him for walking off the site. So the interesting point of going back and reading, there's only about 30 to 35 cases that deal with pandemic or epidemic and act of God out there. And the interesting was that you find the history of that the world has gone through this before with the cholera outbreak, and it was in the 1850s was that case. You have the influenza in the 1900s where there's a lot of cases. You have cases on dealing with smallpox, and obviously then you have some of the more modern cases dealing with SARS, H1N1, Ebola, those types of cases. But overall, there's just not a ton of cases talking about the act of God in the context of a pandemic. The main ones that I was able to locate, and there were actually several of these, were involving school teachers back in the early 1900s when the influenza outbreak occurred. And obviously, at that point in time, the country was similar to what's going through now. They were closing down schools, whether that be by the act of the government saying to close it down or the act of the school board asking that it be closed down. But one way or another, the schools were being closed down. And that went through, that occurred both in the influenza. I found cases involving smallpox where the schools were being shut down. And I think there was even a more recent case in California with the Ebola or H1N1 where there was an issue about schools being shut down. But and now more recent cases are actually trying to get people out of prison because of the situation going on. But that's not a contractual issue. That's kind of a justice issue of trying to get people out of prison so they don't catch this virus. Interestingly enough, though, in most of the cases where it was a school situation, which I think would probably apply in a lot of different scenarios, the school was asserting that it didn't owe an obligation to pay the teacher's salary for that period of time in which the school was shut down, because the school argued that the influenza outbreak or smallpox or polio or whatever it may be had to force the school to shut down, whether it be by the school board decision or whether it be by the county or the state decision to shut down. And the courts pretty much unanimously came down on the side of the teachers in that case to require that the school go ahead and pay the teachers for that period of time. So the law generally is supporting the fact that even a pandemic or epidemic is not necessarily a justification as an act of God to avoid the payment of an obligation or performance of an obligation. I thought that was a little ironic. I truthfully expected it to kind of float the other way, and obviously I'm talking about cases that really dated back to the early 1900s. But just keep that in mind that that's out there. From what I've seen on the act of God concept. But act of God is a common law defense. It is in your contract, essentially. And if you can find a way to assert that somehow that the performance or the payment should be avoided by reason of act of God, then I think that's an argument to be made. Whether it'll fly in today's society or not, I just don't know. I, again, couldn't find anything that was more current that would deal with this issue. There are some other common law theories that come into play in dealing with contracts. One is impracticability. There's also impossibility, and there's also frustration of purpose. And I can go through these a little bit more in detail, and I'm going to try and give you a little bit more detail. I will tell you that even after reviewing the law and trying to understand them in more detail, they tend to bleed together a lot conceptually, and they tend to bleed together a lot also with act of God. So some of the courts kind of use these terms semi-interchangeably as though they mean the exact same thing. And I'm not sure how your local court would react to the situation or how it might interpret these types of common law defenses, but I just want to give you some idea of what's out there. So first one talking a little bit about is impracticability. And there is commercial impracticability, and then there's common law impracticability. So commercial impracticability is actually, the funny thing is it's created by statute. And so most states have enacted a commercial impracticability in connection with sales of goods. And so it's a specific area of the law. If you're in a contract for the sale of goods or purchase of goods, and you've got a contract floating around out there, and you're going to assert that your performance is impracticable at this point in time, you're going to look at the statute that's in effect in your jurisdiction to see how the courts might interpret that statute. Kansas does have a commercial impracticability, and it's what we call Article 2 of the Uniform Commercial Code. And I assume most states have adopted the same kind of concept. But again, it only applies for goods. Goods is a very broad term. Literally, it's anything you can manufacture or move. It doesn't obviously involve investments. But animals, if you're in the farming industry, it can involve animals because that's a sale of a good under the Act. But the courts will interpret commercial impracticability. And so under Kansas law, if you're going to assert a commercial impracticability under UCC, it must be objectively impracticable as a result of the event. So performance that merely becomes more difficult or unprofitable is not enough to establish objective impracticability. There's some examples that are given, and again, some of these concepts aren't really discussed a whole lot in the case law, but some of the concepts that are given, or the examples or comments that are given to us under this Article 2 of the UCC, and I think sometimes examples help us all understand these a little bit better. So in one of the comments to the article, it says a severe shortage of raw materials or supplies due to a contingency such as war, embargo, local crop failure, unforeseen shutdown of major sources of supply or the like, which either causes a market increase in cost or altogether prevents the seller from securing supplies necessary to his performance, is within the contemplation of objective impracticability. So that's one comment they've said.
And I just want to mention that I think a lot of times we see those same type of concepts embraced in a force majeure clause. So even if the commercial impracticability might not specifically apply to your situation, that type of language may be in a force majeure clause in your particular contract. The shortage of labor, inability to find labor or materials or stuff like that, those are things I do see quite regularly in force majeure clauses. And so there is some interplay between that type of a doctrine and contractual law that we see.
So if you have a clause in there that says force majeure applies if you're unable to obtain labor, would it apply in a situation like we have right now where there's social distancing and you're not allowed to go to work unless you're an essential person?
It's possible. Now I see with oil and gas in a lot of states, they've been put in that essential category of producers of oil and gas. And so that might, go against the type of argument that you can't get labor, but every state is treating this differently. And obviously if you have a situation where you can't get labor for one reason or another, that certainly might fall under a force majeure event if it's described in that way in your contract.
Yeah, and the Uniform Commercial Code does say the parties can contract around this obligation. So again, go back to read your contract, because if your force majeure provision does pick this up, the question might be not whether it's implied. If it's implied, it's objectively impractical. But maybe if it's written out, it could be more of a subjective standard than an objective standard, depending upon how the language is written in your particular contract. So just keep those, again, it's very confusing, but those concepts are out there, and you got to look at where it's being utilized in your contract. If it's not utilized, then you're going to a common law scenario, and you got to look at it in sales. There's also a common law commercial impracticability or impracticability. And I was talking a little bit about the sales concept. The common law would apply in typically your other types of contracts. And generally, Kansas defers to what's called a restatement of law. And it says where a contract is made, a party's performance is made impracticable without his fault by the occurrence of an event, the non-occurrence of which was a basic assumption upon which the contract was made, his duty to render the performance is discharged unless the language or circumstances indicate to the contrary. That's a lot to be said in interpretation of that deal, and that's obviously why laws do get passed and get confusing in how we apply them. But common law does allow that to be included. There's Kansas courts have obviously distinguished between subjective and objective, and they will make a distinction. So be careful about whether it's objectively impracticable or subjective, depending on again, maybe if it's written in your force majeure clause, may be treated differently. Some states are different than that. Missouri may have a totally different definition of impracticability under common law. They may allow more subjective, whereas Kansas is more an objective standard under the common law application of the rule. So just reach out to your attorney, and maybe he can give you some guidance as to how that might be interpreted in your particular situation. I'm going to jump over to the concept of impossibility, and again, impossibility is just a strange as impracticability, because they're used a lot of times interchangeably. I was able to find one case, and again, the funny thing, this involves schools, and this was a case out of North Dakota, and this was years ago. But the court in that case, it was almost involving like a school bus driver, and back then it was kind of ironic the way the contracts were written, but the school bus driver had to provide blankets for the warmth of the kids and the teachers they were picking up and those types of deals. But the contract was fairly loose about how long the obligation was to go on. And unlike in the teacher cases, which generally ruled normally in favor of teachers on an act of God, in this case, we're talking about impossibility, which I still think may even be part of an act of God in some courts. The court in this case ruled against the school bus drivers and essentially said that they viewed it as though the fact that because of the epidemic that was going on, that the school bus drivers were not entitled to be paid. And they said that in that case, they say impossibility may arise upon the sickness or death of either party, or the inability of one party to give or receive performance occasioned by the prevalence of an epidemic. And they cite a case out of Maine on that one. It's an extremely old case. But I think when you work with these concepts, you're going to find that, in fact, I was working on a seminar the other day, listening in with some guys, and the distinction between impracticability, impossibility, and act of God kind of got blurred across all types of lines, and cases got blurred in the discussions of how they were going to be approached. The final topic that I kind of have here is frustration of purpose. And frustration of purpose differs from impracticability because there is no impediment to the performance by either party. An example I heard the other day of frustration of purpose, which I think is kind of sounded home to me, was you've been hired by a theater company or a let's say an arena to clean up the arena after an event occurs in the arena. But because of the epidemic or pandemic, the show that was supposed to go on the night before did not go on. It couldn't be performed, and so it was canceled. Now, nothing would then prohibit the parties from continuing the performance. You could go in and clean up the arena after the non-event, but it really wouldn't do anybody any good. And so in that case, the court would look to the concept of frustration of purpose, because why send your employees in to clean up an arena that's already clean because the event failed the night before? So it doesn't have to render, the event wouldn't have to necessarily render your performance impossible. It just would render it so it's worthless to the other party. There's no benefit to be gained by the other party to performing the obligation. Therefore, frustration of purposes as exists in the contract can be avoided. Another example that I found, a couple that we found out there that were, again, in just kind of sections of the law where people kind of try to think these things through and provide examples. One was if you rented a window for a parade, and obviously the parade doesn't go on because of the epidemic or pandemic, they cancel the parade. Are you still entitled to get rent from the gentleman who was going to rent your window to view the parade, or your parking lot to view the parade, or whatever it may be? And the answer is no, because of the pandemic. The purpose of the whole situation was frustrated, and therefore the individual is not obligated to continue to pay you for that obligation. There's multiple examples of that float around out there, and I think everything becomes fairly fact specific to your circumstance, to your situation. Obviously, we are all running around with this pandemic that's occurred, but as Casey really pointed out, it affects industries differently, and your ability to assert frustration of purpose or impossibility or impracticability or act of God may differ because of your industry as being deemed essential. May impact the entire analysis in that scenario. And again, I point out that these are legal theories that use, but the reality is, I know from talking with several of my clients, the law is one thing, the business world is a different world at times, and you've got to make these decisions on what works for you. You can't kick out every tenant just because they haven't paid your rent. I mean, you can do it, but I'm not sure you're going to find another tenant to replace that tenant. So I think the landlords I've talked to and the people I've talked to, I've really given them the advice to work with their tenants. I give the same advice to lenders to work through the process. So I'm going to turn it over to Tom to talk a little bit about what's going on in the litigation world out there, to kind of give you an idea of what's moving on.
So the question is, what can you do if you have a tenant that you want to kick out? You might have a lot of tenants and want to work with them, but you may have one that's been habitually late or not maintaining the property in the condition that you want. Can you do anything about it? And the short answer, at least in Kansas, is for the time being, no. And I'll go through kind of a little bit of a history of what's happened and what is preventing you from taking any action unless you can convince a court that it's an emergency, and I'll go through some examples of that. First thing that happened was on March 17, the governor issued an executive order 20-06, and in very broad language said, I hereby direct and order all financial institutions operating in Kansas to temporarily suspend the initiation of any mortgage foreclosure efforts or judicial proceedings and any commercial or residential eviction efforts or judicial proceedings until May 1, 2020. And that broad language caused many of us to think that you could not bring any foreclosures or any eviction actions, whether they were related to the pandemic or not, and also caused, I think, a number of people to contact the governor's office, because a couple of days later, a few days later, on March 23, the governor issued a new order, Executive Order 20-10, and rescinded the order that I just read from, 20-06, and replaced it with 2010, and made clear that the order applied only to matters related to the pandemic that were caused by a hardship arising from the pandemic. In the interim, however, the Kansas Supreme Court issued an administrative order on March 18th, and basically, without reading through all of this order, shut down the courts with respect to litigation unless it fell within what they describe as an emergency operation or emergency situation. And most of the emergency situations, as you might imagine, were criminal and probate and child in need of care and treatment, judicial offender, or excuse me, juvenile offender, those types of things. There is not even a category for civil actions like breach of contract, breach of a lease, any kind of tort action. In fact, this order specifically stops all jury trials, including jury trials that were in process when the order was entered at the discretion of the judge that was trying the case at that time, and prohibits any further trials or hearings that can't be conducted by video or phone. So, and that order is entered pending further order of the Kansas Supreme Court. Obviously, this only applies in Kansas. I understand there might be some people in Missouri on there, and I don't know what they're doing in Missouri, but I know this is happening across the country. I have a case involving a client that's in Boston, and their courts are shut down. I know that. So this is a common thing that's happening across the country. So what you can do in Kansas, and what is allowed to happen, is you can file some types of proceedings. For example, you could file a mortgage foreclosure case that is not related to the pandemic. In other words, somebody that is defaulting on the mortgage and the promissory note because of some other reason other than a hardship caused by the pandemic. And you can proceed to bring an action, and the other side can file an answer and respond, but you're not going to be able to get a hearing on any of those matters or have a trial on any of those matters until this order is lifted. So basically, the courts have shut down other than for emergency motions, emergency matters. And we've been talking about what might qualify as an emergency matter that the court may hold a hearing on in a commercial setting or in a civil setting, and we've come up with some examples that we could maybe make an argument to the chief administrative judge in your county. And that would be, for example, if you loaned on cattle and your cattle are disappearing, your collateral is disappearing, or you've loaned on equipment or inventory and your inventory is disappearing, you may be able to convince a court to hold a hearing to have an injunction to prohibit those kinds of things from going on. But other than that, you're going to find the courthouse is closed for any type of matter that requires evidence and a hearing in order to get relief. That does not stop people from going forward with discovery. In fact, the order specifically addresses discovery, so that if you have a case that's been pending and you have depositions scheduled and can figure a way to do that and maintain your social distancing, you can go forward with depositions, you can go forward with interrogatories, other types of discovery. But if you wanted to have a hearing, for example, on a motion to compel or a motion for protective order, you're going to have to wait until after the court lifts this order. So that's where we are with respect to enforcing these types of things.
And somewhat to bring this back around to where I started, again, somewhat specific to oil and gas, but this applies really to anybody in the commercial context, is dealing with liens. And my thought in particular was liens of subcontractors. Most of the oil and gas operators, I mean, they understand how contractor liens work. If you hire someone to do a job on your lease and you don't pay them, they can file a lien against your property, against your lease. Subcontractor liens are something that may not be a little bit more abstract, and you might not think about, as upfront as you use contractor liens. And basically, a subcontractor or a material supplier, someone who supplies materials to your contractor, they have lien rights basically to the same extent as the original contractor. And so you can have a situation where you hire your contractor, who goes out, performs the work, hires others to help perform that work, or hires others to supply the materials. And all of those parties have the same lien rights, have the ability to file liens against your property if they aren't paid. The issue and what I deal with in some of these instances is the oil and gas operator pays the contractor before the lien period expires, but the contractor doesn't turn around and pay the subcontractors, or doesn't pay the material suppliers. And you end up with a lien still being filed against your lease because of the subcontractor who didn't get paid. In Kansas, our statutes don't really provide a good way to deal with that. In other states, there are statutes that basically allow you to withhold payment from your contractor until the lien period expires. You can ensure that there aren't any liens filed by subcontractors. Kansas doesn't have anything like that in the oil and gas context. And so you really have to be diligent, especially at a time like this, in going out and figuring out, are your contractors using subcontractors, or who their suppliers are, and making sure that they're being paid. Because if you hire a contractor and you satisfy your debt, you pay your contractor, and they don't turn around and do the same with their suppliers or their subcontractors, it could come back to you, and you could be left holding the bag, especially if the contractor doesn't have any money, or they go into bankruptcy or something like that. You could have a hard time dealing with the subcontractors who are claiming liens against your property. And again, that's not just oil and gas, that's other commercial
Yes.
applications as well.
So just kind of on the commercial application, I agree with Casey. And I suppose what we're trying to say is, in these times, which we don't know where this is going, and how long it will last, and who may survive it, who may not survive it, it becomes important to be probably extremely diligent. You're the best person to mind your own money, and I always caution my clients on commercial real estate developments and items like that, that you got to be careful about subs and suppliers who you may not know about not getting paid. And I have had more than one occasion, multiple occasions, where a GC has taken the money but not remitted it to subs and suppliers, and out of the woodwork comes a sub and supplier, and you're not relieved of that duty, and the lien gets filed, and you still got to pay it. So I just worry about, notwithstanding, the first presentation here was about loans and money being available through those loans and types of things. I do worry about the economic times going forward a little bit, how that may impact us in 3, 6, 12 months from now. And I just think that it's probably prudent to be a little bit more diligent in monitoring those situations and making sure that, in 12 months' time, you're not having to defend against a supplier or a sub, whether it be on your leases or whether it be on your commercial developments, whatever it may be, coming back in and filing a lien against you.
So the question is, what can you do in terms of liening up a property if you need to? Can you file the liens? Can you foreclose on the liens? And there are various deadlines that apply in Kansas that are pretty strict. And the courthouse is open for electronic filings. So you can file your mechanics lien electronically, and I think you can do that all over the state of Kansas now. You can file your lien. Then the question is, can you bring a foreclosure action within the time allotted before that lien becomes stale? And again, the answer is yes, you can bring an action to foreclose the lien, but you're not going to get a hearing on that if you need a hearing right away, unless you can convince somebody that it's an emergency. I will also say, we were talking about this morning among the three of us, the question of whether or not the statute of limitations would run. I think there's an argument that this Supreme Court order would toll the statute of limitations. It doesn't specifically address liens or lien rights, but it says essentially on the effective date, all statutes of limitations and statutory time standards or deadlines applying to the conduct or processing of judicial proceedings is suspended. I don't know what conduct or processing of judicial proceedings necessarily means, but I certainly think an argument could be made that this order suspends the obligation to file, for example, a mechanics lien within 4 months after the last supplies were delivered, or
6 months,
6 months, whatever it is. But on the other hand, if you want to be safe about it, there's nothing that prohibits you from filing it electronically if you want to do that and protect your rights.
And it would also be good to think about if you've got contracts with your suppliers, if you use an MSA or something like that, maybe if you don't already, adding some language in there that gives you the ability to require the contractor to provide information about who the subs are, who the suppliers are. I mean, they don't always want to do that. I mean, your contractors may not always want to give all that information away, and they don't have to under just the statutory language that we have in Kansas. But if you've got provisions like that in your contract, it may help you keep track of those things a little bit better.
And I don't think there's anything that we've talked about here today that will prohibit you from like giving a notice of eviction to somebody or notice of default or anything like that. So you still have all those rights and remedies that you probably need to be monitoring out there, and realize if you're on the other side of that, there's nothing stopping the other party from getting you a notice of default or a notice of eviction. And that may occur. The question is, how far can it go after that? And that's
It's just judicial proceedings,
Yeah.
so I don't think there's any reason why it would be suspended.
I think at this juncture, if there's any questions, I don't know if there are any. Oh, there was since we had the same, I think we had the same audience on that was on earlier. There was a question about whether the PPP funds can be used for rent payments when the lessor is a related party. And I deal with this all the time, where you've got an operating business in a building and it's an S corporation because it has a benefit of being an S corporation. But the actual building itself is owned by the same family member, so to speak, in an LLC, and there's a rent payment between the two. And I have not found anything yet that would prohibit that type of payment from being made from your S corporation to your LLC, even though they're both related. They could actually have this. A lot of them, it's I see are husband and wife, and they both own the S corporation, they both own the LLC, and I haven't seen anything that prohibits that from being utilized. And I can understand why there wouldn't be a prohibition on that too, because again, a lot of times that lessor, that LLC, that's the lessor, or it's a trust, it could be a trust that's a lessor, whatever, potentially has obligations itself to a mortgage lender. And obviously the concept here is to make sure everything keeps moving forward and that everybody can get back to almost like we slowly trickled off the shelf, but what everybody's trying to do is to jump right back on it in 8 weeks from now. And I think if you're not making those rent payments, even though it's a related party, I don't think that puts you right back in the same position you were before. So I've not seen anything that prohibits that kind of payment. Hopefully that answered the question.
Gentlemen, thank you for the presentation. We're going to move from the Wichita World headquarters of Hinkle Law Firm and bring Ed Nazar in. He's in our Kansas City firm today, or Kansas City location today. Little background on Ed. He graduated from Boston College in 1971 and Washburn Law School in 1978, and has been a friend for a very long time. And I'd like to hand this over to Tom and Ed to talk about some bankruptcy issues that might occur in this environment. Gentlemen,
Well,
it's all yours.
What we thought we would do, I'll just go forward first. What we thought we would do is I'm just going to go through a little bit of basic bankruptcy. We think there's going to be, unfortunately, several new filings, a lot of new filings going forward as a result of this, consumer and business. And so I'm going to just go through a little bit of basic bankruptcy law, and then we're going to talk a little bit more. Ed's going to go through the new law that was just passed this year, effective in February, kind of timely as it turns out, called Subchapter 5 of Chapter 11 for small businesses. So I'll go first and just take a few minutes to go through some basic bankruptcy issues, and then I'm going to turn it over to Ed to go through how the new Subchapter 5 of Chapter 11 works and how it may benefit you and how it's been implemented here in light of the pandemic. So the basic chapters in Chapter 7 that you need to understand and what they do are Chapters 7, 11, 12, and 13. They're basically 4 chapters. One of them is a straight liquidation. The other 3 are usually reorganizations, but can be liquidation proceedings as well. Chapter 7 is a straight liquidation. It's what people usually think of when they hear somebody has filed a bankruptcy. You file a bankruptcy, a trustee is appointed to administer the non-exempt assets owned by the debtor, liquidate them, and pay creditors from those funds as the priorities are dictated in the bankruptcy code. Virtually anyone is eligible to file a Chapter 7 bankruptcy, individuals, corporations, although corporations are not generally filed, partnerships generally not filed, but they're eligible. Only people that are really not eligible to file Chapter 7s are railroads, domestic insurance companies, banks, and foreign insurance companies. There's always a trustee appointed in a Chapter 7. The trustee's job is to collect the non-exempt assets owned by the debtors, liquidate those assets, collect what we call Chapter 5 recoveries, which are like preferences and fraudulent conveyances. Some of you who are business people have probably had the unfortunate experience of having a trustee claim a preference from you, but that's the trustee's job. Here in Wichita, the two trustees are Linda Parks and Darcy Williamson. They are handling all the cases now as the panel trustees here in Wichita. There are other trustees in Kansas City that handle cases, and I think there may be another one in Topeka. I'm not sure at this point. Chapter 11 is a reorganization. That's what this subchapter 5 comes is in Chapter 11 of the Bankruptcy Code. It usually is a reorganization, but it can be a liquidation as well. You can file a plan in Chapter 11 case to liquidate the assets or to sell them to a new entity. That's a common plan here in Kansas, particularly with small mom and pop type businesses. Again, anyone is eligible to file. Individuals can file. We have filed for individuals, although it's usually too expensive for an individual to file. Corporations, limited liability companies, partnerships are all eligible to file. If there is a trustee in a Chapter 11 case, it means there's something that's going wrong in the case. There's been some fraud, mismanagement, or incompetence. So there normally is not a trustee in the bankruptcy. I get calls from lawyers all the time asking me about a trustee in a Chapter 11. They're usually not appointed. If they are appointed, that means there's something that's going wrong with the case. Instead, the debtor acts as debtor in possession and has the fiduciary duties of a Chapter 7 trustee, the same duties as a Chapter 7 trustee to liquidate or reorganize, to pursue the avoidance claims under Chapter 5, and make sure the claims that are asserted by creditors are correct. Chapter 12, these have been on the rise of recent, and I think they could be on the rise, continue to be on the rise. These are farm cases. You have to be a family farmer to be eligible to file a Chapter 12 bankruptcy. This is something that was enacted in 1986 because Chapter 11s were not working for farmers because of the absolute priority rule, which I think Ed will talk about a little bit, and also because of the capital gains that farmers experienced as a result of the sale of their property after it had increased in value when they take it with a low basis. Only family farmers or family fishermen are eligible to file Chapter 12. There's been one family fisherman here in Kansas that's filed that I'm aware of. As unusual as that may sound. Family farmer is someone with a regular income and has debts that do not exceed $10 million $10 million, and 50% or more of whom income arises from a farming operation. The advantage of a Chapter 12 bankruptcy for farmers is you can confirm a plan without a vote, like you have to have it in Chapter 11. As long as you meet the statutory requirements to confirm a Chapter 12 bankruptcy, your plan can be confirmed, and you don't have to deal with the absolute priority rule. And now, since a couple of years ago, there is a provision that is effective for them to deal with capital gains that arise from the sale of their farm ground. Last is Chapter 13. Chapter 13 is designed for consumers, but we filed for people who have a business, a sole proprietorship, although they're not very practical for Chapter 13 for sole proprietorships. They're designed for people who have a regular source of income, like a person that works at Spirit or Boeing or one of those types of places. It's a reorganization where you can repay your creditors over a period of 3 to 5 years. People tend to file Chapter 13s, one, because they have to now, as a result of the means test that was implemented in 2005 that would force you to file a Chapter 13 instead of a Chapter 7. But other reasons that you might want to file a Chapter 13 is you have a debt that may be non-dischargeable in a Chapter 7 case, that you could discharge in a Chapter 13 case, or that you could pay over the life of the Chapter 13. Typical example would be back to taxes, back to child support, back to maintenance. You might be able to pay that off over a term of a Chapter 13 plan. Another reason would be you have an asset that you would otherwise lose in a Chapter 7. Typical example that I've seen would be an antique car or a boat, something like that, a fishing boat. You want to be able to keep that. You can pay your creditors the value of that and keep it despite the filing of the Chapter 13. So that's an overview of what you might see from your vendors, your suppliers, your employees, whoever might be filing bankruptcies. Could be your competitor, could be you, I don't know. But we anticipate that there will be more filings as a result of this. So I'm going to turn it over to Ed now to talk about subchapter 5 of Chapter 11.
Thank you, Tom. Bankruptcy, I preface my remarks by saying bankruptcy is a poor substitute for the lack of cash flow. Bankruptcy should be thought of as a shield to protect you from the actions of creditors and not a sword, not an offensive weapon. It protects you from creditor action, typically, obviously, the actions of secured creditors. It is effective when it's used to implement either a restructure or a controlled liquidation. But it should only be utilized after negotiations are either successful with your secured creditor, and then you're implementing a plan in a bankruptcy, or your negotiations have broken down and you need to file. I'm seeing a great deal of defaults being declared, mostly on the basis of covenant default. And I suspect that banks are attempting to engage in restructure activity now, not bankruptcy activity, but restructuring the loans under a forbearance agreement for their own examination purposes. A banker suggested to me that restructured loans during this period of time, when a subsequent loan review comes up, or when a audit comes in through a bank examination, that there'll be less reservation of capital for the problem loans that will have to be put up for these troubled loans, and that will free up liquidity for the bank for further loan activity. So it would be consistent with the whole CARES Act matter. Now, a reorganization bankruptcy is driven by projected cash flow. And that cash flow, you have to demonstrate early on in the bankruptcy case that you have sufficient cash flow to meet current operating expenses and bankruptcy-related expenses and what are denominated as adequate protection payments. Adequate protection payments are not debt service payments to a secured creditor. Rather, they're a lesser payment that's made to bridge the gap for the deterioration or the depletion of the secured creditor's collateral during the interim period in the bankruptcy. The best example I can give is a truck, an over-the-road truck that depreciates with mileage and over time in the bankruptcy process. So at the beginning of 2002, a truck is arguably worth more than it is at the end of 2002. Adequate protection is supposed to bridge that diminishment in value. It's typically used also for creditors that as some form of interim cash flow to a creditor to build creditor confidence in your ability to reorganize. It is to be paid to an secured creditor. That is, a creditor whose collateral is worth less than the loan. An oversecured creditor typically doesn't get an adequate protection payment because they have the equity cushion to absorb any diminishment in value. what I think you're going to see relative to bankruptcy related issues is that bankruptcy now is not a good choice because it's likely to lead to a liquidation. The CARES loan program, I think, will effectively plug the dike in meeting your current operating needs. But in the absence of demonstrating sustainable and predictable ongoing cash flow, I think a reorganization bankruptcy would be difficult to implement at this point. I think later in the year, if your sales are returning but not at a fast enough level, it will be. You know, we spent a lot of time about talking about flattening the curve relative to infection from the COVID-19 virus. What we need is we do not need a flattening of the curve of a return to cash flow, and we need to get cash flow growing as quickly as possible. Now, in the bankruptcy process, I think you folks are aware of the use of debtor in possession loans. They are, in larger cases, DIP loans, debtor in possession DIP loans, are the norm. They're more difficult to find in smaller bankruptcy cases because your local community bank doesn't like the prospect of loaning monies in a reorganization case. Now, the advantage for a lender in obtaining a DIP loan is that they can get a priming lien, a lien superior to all other liens of record. Now, they have certain hoops that they got to jump through to be accorded that treatment, but that's what makes a DIP loan favorable. The possibility exists, I think, with perhaps the second tier of the federal programs that are going to come out, that some of this new money may be used as a DIP loan in a bankruptcy. Now, Tom mentioned that in February, late February of this year, a new provision in the bankruptcy code was enacted, small business subchapter Roman numeral 5 of chapter 11. This has a debt cap of $7.5 million. If you have more than $7.5 million worth of debt, you have to use traditional chapter 11. If you have less, I would seriously urge you to consider the utilization of subchapter 5. The subchapter 5, as Tom may have mentioned to you, is similar to a chapter 12. It's an abbreviated process. It's an expedited process. Optimistically, it will cost less in attorney's fees and accountant fees to implement. There is no disclosure statement that is necessary in subchapter 5 as opposed to chapter 11. The plan process is an abbreviated one. There is no voting requirement of voting of creditors. Creditors can only appear in the bankruptcy case and object. They do not have voting rights. In a regular chapter 11, creditors have voting rights, and you have to carry at least one class of creditors to accept your plan in order to move on to the confirmation process. One of the best benefits of the new subchapter S is there's no requirement for new capitalization. In a regular chapter 11, the statutory requirement is that new value has to be injected into the plan and recapitalized. If you are a small business person, typically all of your money, all of your liquidity is tied up in the business, and therefore you don't have the resources in order to inject new value into the company. Now, the trade-off of that, or the quid pro quo, is that you have to have your you have to dedicate your disposable earnings in your small business chapter 5 plan to your creditors over a 3 to 5 year period of time. One of the interesting things about small business chapter 5 is that it's in a 2-track system. There is either there's a consensual track and a non-consensual track. Now, a trustee is appointed in small business chapter 5, but it's not a liquidating trustee like a typical chapter 7. And the trustee is not to run the business except in extraordinary circumstances. The subchapter, small business subchapter 5 trustee function is to determine whether a consensual plan of reorganization can be entered with your creditors. And so the function of the trustee is almost like a mediator between the debtor and the creditor and the creditor constituency. And the trustee is to be compensated for this function. But if you obtain a consensual plan, one, you have to dedicate your disposable income to it. Two, upon confirmation, the trustee is discharged of responsibility and is entitled to some compensation, but you also get an immediate discharge of the debts at that point. In a non-consensual plan, that is where there are objections to the plan treatment, the subchapter 5 trustee serves as the dispersing agent for plan payments over the 3 to 5 year period, and also will monitor compliance with plan provisions to make sure that you are distributing your monies. To qualify as a small business chapter 5 debtor, you have to have more than 50% of your debt be commercially related, business related. So if you are a small business individual and you have both and a proprietorship and you have both consumer debt and commercial debt and business debt, more than 50% of that debt has to be commercially or business related. The election to be treated as a subchapter 5 case needs to be made at the time you file. And if you don't make that election at that time, it will be waived. No creditors committee exists in a subchapter 5 case, which is really a means to save money because of the presence of a creditors committee in a case. And in a traditional chapter 11 case, and Tom, maybe you disagree, but I look at the committee as almost trying to act like the board of directors for the debtor during that process.
Well, in the typical chapter 11 cases that we see around here, mostly they're small, and most of them would probably fit within subchapter 5. I look at the committee as another expense because the committee hires their own counsel, and so the debtor not only has to pay us as debtor's counsel, but also the debtor has to pay the committee's counsel, plus the debtor has to pay the U.S. trustee fees that are due in a chapter 11 case based on gross distributions, which don't exist in subchapter 5.
Correct.
So you have to pay for a committee and you don't have to pay for the U.S. trustees fees.
So there is a tremendous potential administrative savings in debtors' attorneys' fees, committee attorneys' fees, lack of U.S. trustee fees, lack of committee fees and expenses that would take place in a small business chapter 5 case. There are certain deadlines in a small business reorganization case, and a conference is to be held with the court to determine whether a case will be consensual or not 60 days into the case. Your small business chapter 5 plan should contain a brief history of the business operation, the liquidation analysis, that is there, what is the liquidation value of all assets in the case? What is the equity in that case after subtraction of the liens that are outstanding against that piece of collateral? And you also have to show projected cash flows for at least the next 2 to 3 years in the plan to substantiate that you'll be able to make the payments in the case. The payments have to be for a secured creditor, a creditor with liens, at least equal to the value of their liens, the value of the collateral that is subject to their liens. To the extent that the claim of the secured creditor is greater than the value of the lien, that becomes an unsecured claim that will receive some distribution from the projected disposable income. To the extent that disposable income defined in small business chapter 5 is that is income or revenue that is not necessary for the maintenance or support of an individual debtor or a dependent of the debtor, a domestic support obligation for that individual debtor, or in the case of non-individual debtors, that is business debtors, business entities, LLCs, corporations, partnerships, for the payment of expenditures necessary for the continuing preservation or operation of the business of the debtor. Pretty open-ended what that is. Again, new value does not have to be placed through the plan.
Ed, I think we're about to run out of time, I think. In fact, I think we're past time. I don't know if there are any questions or not. Melissa? I don't think there are any questions for us.
Thank you.
Ed, thank you. Tom, thank you, guys. Tomorrow there will be another webinar on employee benefits, and we hope if you have time and are interested in that you would join us. So thank you, everybody, for attending.